and welcome to this Judicial Candidates Forum, co-sponsored by the Cleveland Metropolitan Bar Association, JudgeForYourself.com, and the League of Women Voters of Greater Cleveland. I'm Catherine LaCroix. I am co-president of the League of Women Voters of Greater Cleveland, and I will moderate. The candidates in this forum are Robert McClelland and Andrew J. Santoli. Our candidates are seeking a term, a 6-year term, on the Court of Common Pleas, General Division. This court has general jurisdiction to hear civil cases where the claim's more than $15,000. So you would expect to see property, contract, personal injury, and other types of civil claims in this court, what you typically think of as a lawsuit filed in a court. The court also has, very importantly, jurisdiction over felony criminal cases. In order to qualify to be a judge in this court, the person must be an attorney admitted to practice of law in Ohio with at least 6 years of experience of legal practice in this state. Our procedures for this forum are pretty simple. I will start the questioning by randomly choosing a candidate to speak first. After that, we will rotate between the candidates for who answers first. I will use a set list of questions. I regret that due to the short time period for this forum, there will be no additional questions from the audience. Each candidate will have 1 minute to answer each question, except for some 2-part questions. And for those, I will tell our timekeeper that the candidates have 2 minutes. There will be no rebuttal. The timekeeper will display a card with a 10-second warning and then a card when it is time to stop, at which point, of course, you may finish your sentence. But we ask that you then stop. I'll ask as many questions as we can to fit into the time allocated for the forum. Now, in order to start, I am randomly selecting someone, and I had trouble last forum with my virtual background getting the mug in the screen, but I will tell you that I am choosing at random a slip from a mug, which will determine which candidate answers the question first. So the winner is Mr. Santoli. So for the first question, Mr. Santoli, what work or other experience have you had that will particularly qualify you to perform the duties of a judge on this court? You have 1 minute.
Thank you and good afternoon. Regarding my experience, most of my experience in practicing law has been with the Cuyahoga County Prosecutor's Office. I do have some civil experience with the probate litigation firm I currently employed at, but for most of my time in my legal career, I was with the County Prosecutor's Office. I was in our major trial unit, which basically means I handled the most serious, complex cases that occurred in Cuyahoga County: aggravated murder, sexual assault, gang cases, and human trafficking cases. I litigated over 100 matters while a county prosecutor. And each time I obtained a conviction in one of those cases, I had to defend that conviction in the appeals court. Now, what does that mean and why does that prepare me for a common pleas judge? Is because as a major trial prosecutor, I not only had to defend my action, I had to make sure the defendant's rights were protected, and I had to make sure the judge was following the law. So being a major trial prosecutor, handling those serious, complex issues, I think makes me uniquely qualified to be a common pleas court judge. Thank you.
Okay, thank you, Ben. Mr. McClelland, what work or other experience have you had that will particularly qualify you to perform the duties of a judge on this court?
This is my 40th year in practice, 31 years in private practice, 9.5 years as a judge on this bench. During my private practice, I was both a civil defense lawyer and also a prosecutor for the city of Westlake for a brief period of time. A wide range of kinds of cases, over 150 jury trials in my private practice, another 150 civil and criminal trials since I've been on the bench. In private practice, I had 7 arguments before the Ohio Supreme Court, multiple before various courts of appeals. And since being on the bench, in addition to dealing with the civil and criminal cases, I've been appointed as one of the mental health docket judges So I've got a broad wealth of experience in a variety of areas. And prior to coming to the bench was a high school teacher when I went to law school at night. So I've had quite a range of experiences over this long career.
Thank you. Now, for the second question, again, starting with Mr. McClelland. And for this question, each of you will have 2 minutes. Do you believe that all citizens have adequate access to legal help and the legal system? Why or why not? And if not, what can be done to make it better? Mr. McClelland.
Well, first of all, I don't think people do have adequate access. There are a lot of things being done to assist them with that. For example, the Legal Aid Society and the Public Defender's Office for civil and criminal matters. So there is some assistance out there, along with the pro bono programs through the Bar Association. But where actually there's a bigger problem is on the civil side, and that is to have representation for the civil cases that are, some people would view them as minor. Obviously, the person who has the claim does not view that as minor. And for them to be able to get assistance and defense or someone to prosecute the claim for them is often very difficult. On the criminal side, the Public Defender's Office and assigned counsel are available to them, so that there is at least an option through our program that everybody who is charged with a crime has the ability to have representation. But it can be enhanced. Part of that's funding. Obviously, there are limitations on what the Public Defender's Office can do, or private counsel, because of the funding that may be necessary for private investigators, for a review by a competent physician or psychiatrist, depending on the nature of the case. So there needs to be some more funding, and the pay rate for the assigned counsel in the Public Defender's Office, I think would be helpful as well, because what they are being paid per hour is very minimal, and it's lower than the amounts that are paid throughout a good part of the state if you go to different counties. So there is access, but it certainly needs to be expanded. Funding is a big part of how to get that done.
Thank you. Then Mr. Santoli, same question. You have 2 minutes. Do you believe all citizens have adequate access to legal help and the legal system? Why or why not? And if not, what can be done to make it better?
Thank you. All citizens do not have adequate access to legal representation. It's an issue of access to funding. We need more funding for our assigned counsel and Public Defender's Office to make sure they're handling the multitude of serious cases that they're assigned. And civilly, it is a huge issue. Legal aid can only handle so much. I know they've tried to expand into other areas, eviction, foreclosure cases, but there are many low-income individuals that simply cannot find adequate legal representation for their civil matters. It's a huge gap in our justice system. And there are many ways that we can attempt to solve it. I think funding, pro bono work is the probably 2 most easiest ways. We've got to get legal aid more funding. We've got to encourage attorneys to take these types of cases pro bono so that low-income individuals can have representation in their divorce proceedings or their eviction cases or their foreclosure cases. But I do think criminally, obviously everyone charged with a felony does get an assigned counsel. I think those assigned counsel fees are on the low side. We could make those improvements so that the fees are larger, so that more attorneys are drawn to representing indigent individuals in our common police court. So I think it goes all the way back to funding. We need more funding to provide adequate representation, both criminally and civilly.
Okay, thank you. And then Mr. Santoli, next question. What do you believe are the causes of the high rates of minority incarceration? Anything the courts can do to address this issue? Focus on the courts.
Well, the number one issue is the judge is the person who decides whether an individual is sentenced to probation, they're sentenced to some sort of treatment, they have access to treatment, or sentenced to prison. And so the judge has to understand that not everyone has the same access to opportunities that they have had. I'm a white male that comes from a nuclear family. Mom and dad was in the home. They provided me good support, good access to education, access to medical care. Not everyone had the same opportunities I had. And you have to empathize with the people that come before you to make sure you're levying a just and equitable sentence. You know, my wife is a different race than me. She's Puerto Rican. She grew up in the city of Cleveland, grew up poor, single family household, English as a second language. And throughout our relationship, we've always had conversations about her experiences versus my experiences. And especially within the last 3 or 4 months, those conversations have intensified. And so as a judge, you just have to realize individuals have different experiences, trauma that you have to recognize and empathize with for an equitable sentence.
Okay, thank you. Then Mr. McClelland, same question. What do you believe are the causes of the high rates of minority incarceration, and focus on whether you think there's anything the courts can do to address the issue?
Well, the courts can certainly do things to address the issue. And one of those things that I started several years ago, Judge Russell Adrian from the municipal court began an equal access to justice program through the Ohio Supreme Court for all new judges and judges as we continue on the bench. And it's an awareness of the kinds of folks that we're going to see before us and being sensitive to what their needs may be, what is the best way to handle their cases, and to try to avoid any kind of consistent improper sentencing that might go. The example was, are these people, when we get pre-sentence investigation reports that tell us a great deal about somebody's background, traumas they've been through, physical and psychiatric problems, which may help us decide where we more appropriately can handle cases on probation rather than just simply incarcerating people. And so that the awareness is being brought to the forefront by the Supreme Court. We need to be aware of that and think of that each time we're involved in sentencing an individual.
Thank you. The next question, you'll have 2 minutes. The courts have always faced challenges in improving fairness and efficiency. I think the current pandemic presents unique challenges. What methods do you believe are best able to assure fairness and efficiency in the current environment?
We're taking as many steps as possible to ensure those things, but it's a real balancing act and difficult. For example, think about the wearing of face shields by a witness, the necessary face shields or masks for the jurors. When people are selecting a jury, they want to see what kind of expressions those jurors may have on their faces. So do we require people then to simply wear the face shields while they still wish to be wearing a face mask and have to consider their safety? We have to make sure that there's an ability for communication between the lawyers and their client. We actually have headsets that they can then privately speak to each other during the course of the trial because they're not sitting immediately adjacent and whispering into each other's ears. We're trying to make sure that people are willing to come down as jurors, not have some fear, and have proper social distancing so that they are not being exposed to any kind of a problem while involved in the trial. We're no longer going to have a large jury pool. Instead, jurors will be asked to call in an evening or 2 evenings before and be able to find out whether or not they've been asked for a specific panel. And they only will have that one jury trial with that one case. And when that case is completed, their jury service will be completed. It's not the most efficient system. Just think about it. We have a 23-story building and only 2 people are allowed in an elevator at a time. And to get up 30 or 40 people for a jury pool for jury selection is going to be quite a challenge. We're trying to use the medical mart across the street, which has large rooms that could accommodate large numbers of people and allow for jury selection in that setting, and then possibly moving to a courtroom when you've reduced it to a 12-person jury, for example, in a criminal case with maybe 2 alternate jurors. And that's some of what we're trying to do to respond and react to this crisis and keep business working as best we can here in the courthouse.
Thank you. Mr. Santoli, the same question. You also have minutes for this. Courts have always been challenged in achieving fairness and efficiency. The current pandemic poses particular challenges. What methods would you suggest as appropriate ways to assure fair and efficient procedures in the current environment.
Thank you. I've actually had the opportunity to already try a case during the pandemic. I had a trial in Medina County Probate Court in late May over a guardianship matter that was a full day hearing trial. And it was, suffice to say, the most interesting trial I've ever had to conduct. Myself and co-counsel were at separate ends of the table. We both had masks on. The witness had a mask on, and all of the other witnesses that were called to court had to wait in their vehicle until the witness that was testifying was finished. We would text that witness to come up from their vehicle. They'd be checked through security, come up to the courtroom, and in between the witnesses, the magistrate would wipe down and sanitize the witness chair. Our client had to sit behind us, typically where the gallery would sit, and we would have to text him if we wanted to communicate with him. So I think that experience was invaluable, seeing what worked, what didn't work. Communication amongst co-counsel and communication between attorneys and their clients is incredibly important. We've got to maintain that communication. For civil cases, I believe we can allow maybe cell phones out on the table so that the attorneys can talk to each other and talk with their clients via text message. And for defendants, we're going to have to provide some sort of mode of communication so that they're able to confer with their attorneys without breaking that physical social distance barrier. And it may be a requirement of headsets like the judge suggested, or maybe we have to provide temporary phones for them to use during the trial and have them sanitized afterward. And then the most important aspect is the right to a jury trial. We've got to make sure that we're bringing the public down to a safe place. Being a 23-story building prevents very unique challenges. We need to find some space, and the medical mart might be that best space, so that we're not being inefficient in our moving of people in and around the building. So I would be all for trying to find more space that is on ground level. Thank you.
Okay, thank you. And now for the next question, Mr. Santoli, we are here in a judicial election. Let's talk about what you believe to be the appropriate role of courts or judges in our political process, and please, for the benefit of our viewers, distinguish judges from other elected officers.
Yeah, in the state of Ohio, obviously, our judicial elections are a little bit unique. On the ballot this November, you won't have a partisan ID. You won't know whether an individual is Democrat or Republican. I ran as a member of my Democratic party in the Democratic partisan primary. Judge McClelland is a Republican. I think it does shape your viewpoint on who you are as a person. I obviously share the many ideals, morals, and values of a Democratic person. I'm a proud Democrat, and those values have shaped me throughout my adult life. However, once you obtain judicial office, you kind of have to make sure you're an independent individual that is making decisions based on the law and the facts of the case. And so partisan politics should play absolutely no role in any decision that you make as a judge. It's a unique system that we have in Ohio. I mean, I would be for a merit-based system as opposed to an elected-based system, but it's not what we have. And so that's, I think, how it interplays and shapes our politics.
Thank you. Mr. McClelland, the same question. We are in the midst of a judicial election. What do you believe to be the appropriate role of courts and judges in our political process? And please, for the viewers, distinguish judges from other elected officials.
Anyone on the bench who rules based upon a political point of view does not belong on the bench. It is absolutely a non-political position that's been forced to be politicized by being through this election process. If you were to look at the list of people in our court and around the state of Ohio and not have an idea about their party affiliation, I think people will be very surprised based upon their performance. The politics has no right or place in the courthouse, period. Cases have to be decided upon the facts and the law, and that's it. So it's not appropriate. It's different than partisan politics. If you're involved as a mayor, if you're a state representative, that's a whole different ballgame, and that's fine for that. But as far as judges are concerned, it has nothing to do with it. Shouldn't be on the ballot anytime at all. It should be simply a matter of the experience and qualifications of somebody going to the bench, period.
Okay, thank you. Related to that then, Mr. McClelland, in view of the fact that judges are elected, how can we best assure voters that judges are independent of special interests? Please discuss the role of campaign funding in that connection.
Well, there are limitations on the amounts for judges at each level of how much funding they can receive in contributions, but it is an issue. I mean, you have to, again, divorce yourself from the idea of who may or may not have contributed to your campaign when it comes time to make any kind of rulings or decisions in cases. But it doesn't make a lot of sense. I mean, you're right. Here you have many times the best sources of funding for judges' campaigns are lawyers, both the civil and criminal bar, and then family and friends. You don't see any special interest at our common pleas level. You might at the Supreme Court of Ohio level, but you don't as a common pleas judge, I can promise you. So it really is, I think, another one of those reasons why, even though merit selection has been turned down twice since I've been practicing law, that it makes much more sense to get funding out of it and to get any kind of politics out of it. That it is a concern, but we have to run, and to run, you have to have some contributions.
Okay, thank you. Mr. Santoli, the same question. How do you believe we can assure the voters that judges are independent of special interests, and discuss campaign finance, please?
Well, I think the limitations on campaign contributions is a big factor in ensuring voters that we're making decisions based on what's presented to us, how the facts apply to the law. I don't think that there's an issue, like the judge said, with special interests trying to buy common pleas court elections, either in this race or any other race. The limits are too low, and typically, we're not raising much money from family or friends or lawyers. It's usually enough to send out some mailings and contact some voters and buy some yard signs and maybe some pens and things of that nature. It is an issue as you go up to the Court of Appeals and the Supreme Court. But we have to strive to keep politics and funding campaign contributions out of everything we do, because judges have to be above the fray. And there has to be a sentiment from the public that judges are making their decisions solely based on the law and the facts.
Thank you. Now, again, Mr. Santoli, being a judge, you would be confronting people engaged in a dispute. How do you deal with difficult people, including peers, lawyers, clients, or litigants, and discuss this in the context of serving as a judge?
Yes, I think as a judge, you're going to come across individuals that are either upset for being in the courtroom if they're charged with a crime, or you may have civil litigants that are upset with being in a courtroom, and you may have lawyers that aren't always conducting themselves in a proper manner. I think the first thing you have to have is patience. I think a judge needs to be a good listener. The judge needs to know that they're not always going to have all the answers because of how specific the law is as it applies to criminal law and civil law. And I think if there is an individual that's before you that is upset or losing their temper, a judge's responsibility is to de-escalate the situation and to make sure that that person at the end of the day, to that judge's best ability, that the system has worked and that the system has not tried to overburden that individual. Patience is something that should rule the day, and being respectful and treating everyone with dignity is how a judge should start their day and end their day.
Thank you. Mr. McClelland, the same question. How do you deal with difficult people, including peers, lawyers, clients, or litigants, and discuss this in the context of being a judge?
Well, you treat everyone with dignity and respect. You listen. There are times you need to let people let out some steam and get things off their chest, and let them do that. If you find that tempers may be rising, and maybe that time for a recess or a little timeout, let everybody's tempers cool, and to make sure you as a judge don't lose your comfortable and calm demeanor that you're supposed to have on the bench at all times. So those kinds of things seem to work. Sometimes a little bit of humor to get people to take the edge off is helpful, to let them realize that maybe they are behaving in a way that isn't the best for their own case or for what's going on in the courtroom. Those kinds of techniques we all use to de-escalate, to reduce the tension of the situation. They're in a courtroom. It is an adversarial proceeding, so you expect people sometimes to let their tempers get the best of them. You got to keep it calm.
Thank you. Mr. McClelland, could you describe or discuss any circumstance or a common ethical issue that might arise in a proceeding before you and how it would be handled? That is to say, if you perceive possible unethical conduct occurring, how do you deal with it?
Well, I guess I thought there were two parts to that question. One was if I have a problem ethically, for example, recusing.
Oh, no.
Okay. Well, we have under the code of ethics, if we see an ethical problem, if it rises to a certain level, we are under a duty to report that to disciplinary counsel of the Ohio Supreme Court. And that does occasionally happen. Fortunately, I've not had to do that. If we see something that we think may be inappropriate, we've got to talk to the parties or talk to that specific party or their counsel and explain that they're either getting into dangerous waters, or if they continue on that path, I will be required to report that and may be required to stop the proceedings in the case until that's ironed out by the disciplinary counsel. We've got to follow, there's fairly strict rules. People don't always believe that about lawyers, but there's fairly strict rules we are to follow. And we, as the sworn kind of keepers of that responsibility, have a duty to report it if it does occur in our presence or may appear to be on the verge of occurring.
Okay. Thank you. Now I'll try to phrase the question more cleanly so that make it clear. What I'm saying is, if you're on the bench and you perceive what appears to be unethical conduct occurring, how do you handle it?
Yes, as the judge stated, we have clear rules and a code of conduct that as lawyers and judges we have to abide by. So if there's clear unethical conduct, we have a duty to report it to the disciplinary counsel. But furthermore, if we see a lawyer or a colleague maybe trending in the wrong direction, I think we need to take it upon ourselves to warn them and say, maybe it's time you take a step back and reevaluate what you're doing. Because as judges, as lawyers, it's our responsibility to make sure every citizen has faith in the judicial system. And we can only have faith in the judicial system if lawyers and judges are ethical. And so if you see unethical conduct, you have a duty to report it.
Thank you. And now, Mr. Santoli, what qualities have most impressed you in judges before whom you have appeared, and which qualities have you worked to emulate?
Sure. There's a lot of qualities that make up a good judge. A person needs to be hardworking. They need to be respectful. They've got to be intelligent. They've got to understand how to manage an efficient docket. And they have to have integrity. Now, above everything else, when an individual enters that courtroom, they have to know that they're getting a fair shake. And whether that be a civil litigant or a criminal case, understanding that judge is going to do the right thing. That judge is going to apply the facts to the law. That judge is going to be hardworking. They're going to be a student of the law. They're going to be patient. They're going to treat everyone with respect. And at the end of the day, they're going to make the right decision. Those are the qualities that instill faith in our judicial system. So those are the qualities that I would strive to have as a judge. And I hope I've already exhibited as a lawyer.
Thank you. Mr. McClelland, the same question. What qualities most impressed you in the judges before whom you have appeared, and which of these qualities do you work to emulate?
Judges that had experience as trial lawyers was a huge issue, because they tend to allow you to try your case and not get in the way and tell you how to try your case. So they don't invade what you're doing. They remember what it's like to be on the other side of the bench, what it was like to practice law. They don't get excited about having a robe on and realize they're the same person yesterday that they are the next day when they are now become a judge on the bench, and don't get what some of us refer to as robitis. They listen, they evaluate, they make fair decisions. Most people, they realize judges have got to make the call. And as long as they feel they've been given a fair hearing and a decision is made, they can live with that decision. It's an adversarial process. Nobody wins all the time. So you want that kind of ability, and the ability to talk with a judge and hope that and expect they're going to listen and give you a fair response to whatever your inquiry might be.
Okay, thank you very much. I see our time is up. On behalf of our debate sponsors and the voters who need to make this very important choice, I would like to thank you both very much for participating.
Thank you.
Thank you for the time. We appreciate it.